Be seated. Okay, next case we have on the docket is Armanta Waters versus the state. And it's Ms. Lennon, is that correct? Yes. All right, I'm going to assume 5 minutes for rebuttal unless you tell me differently. And you may proceed.
May it please the court.
Yes.
My name is Valerie Lennon, and I represent the appellant Armanta Waters. At this time, may I reserve 2 minutes for rebuttal?
You may.
There are 2 issues before the court today. First, impeachment testimony, and second, sufficiency of the evidence. Unless there are questions on that second issue, I would like to stand on the briefs on that issue, unless the court has questions on that. So turning to the facts of the case, I realize that the court is apprised of the facts, but because the issue is facts intensive, I would like to go through it really quickly. The charges in the case are first-degree murder and robbery. Mr. Waters was charged as a principal with first-degree murder. The facts of the case are that Mr. Waters, Mr. Head, and Mr. Graham traveled by car from Georgia to the Daytona Beach area in order to buy marijuana from Mr. Berry. Upon arrival, Mr. Berry invited them into the apartment. Now, Mr. Waters had bought marijuana from Mr. Berry before. He used his own identity, his own name. He didn't try to disguise his appearance or anything. He had sufficient cash on hand to buy marijuana from Mr. Berry. Once inside, they'd just driven down from Georgia, he asked to use the restroom. Mr. Waters asked to use the restroom. While he was in the restroom, Mr. Graham and Mr. Head began beating Mr. Berry. While they were attacking Mr. Berry pulled for his girlfriend to grab his gun. Presumably, while the girlfriend turned to go get the gun, Mr. Graham shot the girlfriend. It was only after Mr. Graham shot the girlfriend that Mr. Waters emerged from the restroom. These are the facts that everyone agreed upon at trial. Those were undisputed. When Mr. Graham was on the stand, the state asked him, did Mr. Waters take part in planning the robbery? He refused to answer that question. The state did not ask him on direct examination what Mr. Waters was doing in the restroom. On cross-examination, defense counsel asked him simply, was Mr. Waters in the restroom during the beating? The answer was yes. On redirect examination, here's where the problem arose. The state asked Mr. Graham, what was Mr. Waters doing in the restroom? Whatever answer Mr. Graham gave.
Was there an objection to that question?
Yes. So that's where the problem came in. This was the impeachment testimony. The state was allowed to impeach him with his prior, and there was another issue with the prior deposition testimony.
No, was there an objection to the question that wasn't answered?
I believe so off the top of my head.
What was the objection?
The objection was that the defense counsel was not noticed on this deposition because it was in connection with another case.
But that seems to go more to impeachment, right?
Correct.
So what was the objection to just a simple question of, do you know what he was doing in the bathroom?
I believe it was that it exceeded the scope of cross-examination. Off the top of my head, I don't have
And
it.
the trial judge has pretty broad discretion on that, right?
Sure, and the standard is abuse of discretion. So this is just one part of the problem here. And the real problem with this is that, so the answer is that the plan was, didn't you testify at this prior deposition that the plan was he was supposed to grab marijuana?
Does the record show whether Mr. Graham's prior deposition was a discovery depo, or was there testimony, or what type of deposition was that?
Off the top of my head, it was a deposition in another case. It wasn't even this case. It was related to a co-defendant in another case that Mr. Waters' attorney was not noticed on, didn't have a chance. When Mr. Waters' attorney tried to depose Mr. Graham, he said he wasn't going to answer these questions. So that was a whole nother issue. So we get to this is impeachment testimony, and Mr. Waters' attorney can't cross-examine him on this answer. So the answer is, sure, he was supposed to grab the marijuana from the bedroom. So that's out. The trial court gives a limiting instruction. Defense counsel objects, gives the limiting instruction. So there's that. That's problem number one. Can't cross-examine him on that. And then we get to closing argument. And then the prosecutor tries to argue this as substantive evidence twice. Not once, but twice. So here we have an even bigger problem. So sure, there's a curative instruction, sure, there's a motion for a mistrial, but now the jury's heard this 3 times. And even most legal minds have difficulty understanding the theory behind impeachment evidence. So in theory, impeachment evidence is only to be considered for credibility. It's not to be considered for guilt or innocence. But to ask the average juror to only consider, hey, you heard that Mr. Waters was planning the robbery, but you can only consider that for credibility. You can't consider that for guilt or innocence. It's really unrealistic or impractical.
But that's what the standard jury instruction says.
It's what it says, but it's really unrealistic. They should have granted the mistrial here. The fact of the matter is that Mr. Waters was 19 years old and he's serving life imprisonment as a result of this trial. The only evidence that linked, so put that aside, put this impeachment testimony aside, the only evidence in this trial that linked Mr. Waters to the robbery was Mr. Berry's testimony about what happened when he came out of the restroom. And what Mr. Berry said was that Mr. Waters didn't act surprised when he came out of the restroom, and as they're going out the door, he grabbed some marijuana. That was it. So if you're the average juror, and you're trying to decide if Mr. Waters is guilty as a principal of first-degree murder.
So after he came out of the restroom, he immediately left.
No, they stood there for a minute, and I believe Mr. Berry said they told him to be quiet. Mr. Waters didn't act surprised, and he grabbed marijuana as he walked out the door, as they ran out the door, as Mr. Berry's shooting at them.
There wasn't any continued fighting or tussle or anything after he exited the restroom?
No.
Okay.
So you're the average juror, and you're trying to decide, and you've already got this in the back of your head. It's likely that this tipped the scales in favor of guilt. And if we, the people, are going to convict Mr. Waters at 19 years old and send him to jail for the rest of his life, we've got to do it the right way. We've got to give him the trial that doesn't cut corners, the trial that the Constitution affords, a full and fair opportunity to defend the charges against him, and this was not it.
So the improper impeachment, as argued here, was in response to a question that he actually answered. Is that correct or not? He did answer or didn't answer? Because you started out talking about a question that he refused to answer.
So on direct examination, he refused.
Right, because there's a lot of it. So I'm trying to make sure I'm remembering the right question and answer. Did he answer this one or not? And it was about what was your client doing in the restroom, right?
So here's my notes. I don't have that actual section in front of me, but the transcript is pages 502 through 503, and it's over objection. The state was permitted to impeach his own witness, and it says, "Isn't it true that under oath on May 24th?"
No, before that, before the impeachment, what was the question asked?
I don't have it in front of me.
Oh, okay, all right. That might be important though. Right, and whether he answered it? Did he answer it? So you don't know what the question was?
I don't have
You don't
it.
know if he answered it? Okay.
So he doesn't answer what the state wants him to answer.
Right.
And then they come out and say, the prosecutor recites what he said in the previous. So whatever he answers is not what they want him to say. I think he says, "I don't know," or whatever. And then they say, he was supposed to go in the room, and grab the marijuana. Wasn't that your original statement? So there was an objection, and then that was the part that comes out. Because it was part of the plan for him to go back, for him to ask to go back to the bathroom and go close to the bedroom. So he never says this part, but the state comes out and says this. That was on redirect. So again, the purpose of redirect is to limit or clarify what happens on cross-examination, not to elicit new testimony.
Yeah, but again, we already established pretty broad discretion there, right?
Sure.
So, I mean, if
But
that was
not
given-
unlimited discretion, right?
Okay. But that seems,
Again, because Mr. Waters can't cross-examine him on this.
right, it does seem like whether there was improper impeachment is it seems like it's an entirely different issue than whether the trial judge should have allowed the question on redirect. Am I missing something there?
Can you say that again? I apologize.
Well, whether there was improper impeachment, right? That seems like an entirely different issue, different argument than whether the trial judge erred in allowing the question to begin with on redirect as outside of the scope.
So
Are those two different arguments?
No, I don't
Okay.
think so. So the question, okay,
So if the trial judge allows a question that he or she should not have allowed on redirect because it's outside the scope, there might not be any impeachment at all in that situation, correct? Two different questions.
it could be, but then it gets murky. So the
Right.
question on cross was he located in the restroom the entire time? Yes. And then the question that was objected to on redirect was what was he doing? That was objected to.
That's the objections beyond.
Overruled as beyond the scope.
But that's a different argument and different issue than whether there was improper impeachment.
So that was overruled.
Hold on.
Okay.
Yes or no? Different arguments.
I don't think so. I think it's all tied into one because of the answer that came out of it.
Okay.
I think it's all tied
Walk me
together.
through it then, make me understand.
Okay. So we get the overruled objection, and then this is directly the answer that we get. So then it gets muddy, and then it continues into closing argument because it's already out there.
Well, on redirect, the question is asked. There's an objection. Hey, that's beyond the scope. Trial judge says, I'm gonna allow it, right? So the question's asked. Then we get an answer, right?
Right. And I think
The state could have let it go and done nothing else with it, moved on, right? But instead, they ask an impeaching question, correct?
Correct.
Right.
And then we
So
get
one
the-
argument is about whether the first question is beyond scope. The other argument is about whether the impeachment question is proper. I'm trying to understand your arguments.
And I'm trying to understand your questions, Your Honor.
Okay.
I think they're all tied together, but I think
Okay. Well, they clearly are, because you wouldn't get the impeachment without the first question.
okay.
But the alleged error is different.
I don't see it that way. I see it as all tied together because
Okay.
the questions are all in one. But the real error is what came out of it.
Would there have been
I mean,
an
however
impeachment
it gets-
argument? Would you be arguing improper impeachment if the state had moved on after they asked what was he doing in the bathroom, and then the witness said, I don't know. If the state had moved on and moved on, there would be no impeachment argument at all.
No impeachment argument at all. No, I would
I think that proves they're different arguments,
Yeah.
but go ahead.
So we would not be talking about it here.
Gotcha.
The real problem is what came out of that.
I'm a little confused as well. What was the impeaching question? So what was he doing in the bathroom?
What was he doing in the bathroom?
And that would be a different question than why was he in the bathroom? Wouldn't it? Well, because there was testimony that he was using the bathroom, for example. Couldn't you impeach that by saying, well, what was he really doing in there? And that's different than why did he place himself in that bathroom to begin with? Was he part of this conspiracy?
Can you ask that again, Your Honor?
Are those two different questions? What was he doing in the bathroom, or why did he go to the bathroom?
I don't see those as different questions. I see them as the
Does
same.
it one show motive, a common plan between these conspirators?
I see them as the same.
Okay.
So the question on cross was simply located in the bathroom. The question on redirect was what was he doing or why was he in the bathroom?
You don't see those as two different things.
I see them as motive, yes.
What was he doing in the bathroom is different than why did he go to the bathroom to begin with? Why did he place himself there during the beating?
I read the trial transcript as motive, the way the question was asked as motive. And so the real harm, regardless of how the question was phrased, was the impeachment testimony that came out of it.
So you're not arguing beyond the scope. That you're not making that.
No, Your Honor, it's the impeachment testimony that came out of it,
Gotcha.
and then how that was ultimately compounded in the closing arguments. And what that happened was, so moving to that closing argument, so now we already have this out there, one. So if it had just come out here, just on redirect, and that was it, that was the only time the jurors heard that, we have a much different case. Now we're in closing argument, and they've heard it a total of 3 times now.
So when you say in closing argument, I'm assuming you're looking at, I think it's on trial transcript, page 751. the prosecutor, when I asked him about his prior statement, he agreed that he did, in fact, in a sworn statement, originally say that Mr. Waters was going towards the bathroom as part of the plan because he knew that the drugs and the money were close to the back of the bathroom. And it was that I believe the prosecutor saying fact. The judge then comes back and says, it's not a fact, it's impeachment. Is that what you're talking about as far as compounding it? It moves from being impeachment, an inconsistent statement, to the prosecutor saying, this is a fact, meaning jury, this is actual evidence.
Correct.
Okay.
And it happens twice. So the trial judge warns the prosecutor, you can't argue it as substantive evidence. Okay, goes right back out and does it again. Defense counsel moves forward.
Well, hold on, there was an instruction, right?
An instruction,
Yeah.
correct. We do have, so it's the end of sidebar, goes back and reads the instruction. I think it's number 9. I think it's page 13. So the judge reads the instruction, and then we go back out. This is pages, transcript pages 748 through 753. Goes right back out. So Mr. Waters knew this was going down, and then that's the second time that happens. So now they've heard it 3 times, and it's really hard to unring that bell for the jurors to unhear what they've heard 3 times now. So unless the court has any further questions, I would ask the court to, Mr. Waters is serving life imprisonment. He was 19 years old when this happened. And I would ask the court to reverse this, to award him a new trial, the one that the Constitution affords. And I'd like to reserve the rest of my time for rebuttal, if that's okay.
Thank you.
May it please the court?
Yes.
Marissa Giles on behalf of the state. I do want to read that portion of the transcript with the redirect and the questioning that we're discussing here. This is on page 499. So the question that leads into this impeachment initially, the question by the prosecutor is, Mr. Graham, you don't know if Mr. Waters was in the bathroom the entire time, correct? Answer is, he was. Question, you know for certain that he was physically in the bathroom the entire time? Answer, while I was present in the apartment, he was. Question, okay, was he actually using the bathroom? The answer is yes. And there is no objection to any of those questions. And from that last question, was he actually using the bathroom? Answer yes, is where we get the impeachment from the deposition, where Mr. Graham has previously testified in this deposition that the purpose for him being in the bathroom was to, use that connected room to go steal the marijuana and the cash. So there is no objection to that.
Inconsistent?
Yes, I truly believe that they are inconsistent. Why
he was back there waiting for this meeting to occur, he did use the restroom. How are those inherently inconsistent?
Well, because his testimony was, I know for a fact that he is using the bathroom, whereas his previous testimony...
Do we know that he wasn't?
I'm sorry?
Do we know that he wasn't?
I mean, we don't know that he wasn't.
Nothing in the record?
Nothing in the record, but we do have Mr. Graham, after he is impeached with his prior testimony, saying, actually, I don't know that he went to the bathroom. So, I mean, there is that, that the impeachment at that point, he changes his answer after he's impeached with the deposition. But I do believe that they're truly inconsistent statements. And the state here is allowed, well, actually, I want to clarify something. It appears from the briefs to me, maybe I misread them, but it appears that counsel is arguing that, as to one of her points, that the trial court did not properly grant a motion for mistrial as to the impeachment itself. However, that motion for mistrial was never made as to the actual impeachment during the impeachment questioning. So I do want to make a point that in and of itself is unpreserved. And, whether or not it's compounded in closing, I think is a separate argument. But it appears to me from the briefings that was a point that was made, and that is a point that is unpreserved. But as to the impeachment itself, the state is allowed to impeach its own witness. I don't think there's any argument there that the state wasn't allowed to impeach the witness. I guess the question is whether or not this was a truly inconsistent statement, which I know we just spoke about, but whether or not the purpose of calling the witness was for impeachment only, or if there was another purpose behind it. And I do believe that there's record evidence to show that this was not solely for the purpose of impeachment. The prosecutor states multiple times that I'm calling him for the truth, to tell the truth, I'm calling him for substantive evidence. Then he does give this entire direct examination. I know that opposing counsel mentioned some questions where he refused to answer. There was a proffer, and then there was the actual direct. And on direct, he did answer a large majority of the questions. He did refuse to answer some, but most of the direct he did, in fact, answer. And then he does the cross. He testifies on cross that, Mr. Waters was in the bathroom the whole time, and then we get to this whole impeachment issue, and that kind of leads into the closing. But as for the closing, it's our position that the comments did not go to vitiate the entirety of the trial. They were 2 comments. Obviously, they were improper comments. The court properly sustained the objection to those and gave curative instructions on both of the comments that were made in closing.
And the third time, the judge said, before the third time, which fortunately for you, there wasn't a third time, because the judge's comment was, if you do it again, I'll declare a mistrial.
Right.
You can't say it's a fact.
Right.
And your trial counsel said it twice before, it's a fact, right? Clearly improper.
Clearly improper, and we're not disputing that wasn't improper. It was.
Was inflammatory, right? It was misled the jury, right?
Correct.
Okay.
They were improper comments, but the court here is in the best position to gauge the prejudicial effect of those comments on the jury, considering the entire circumstances of the trial. And the court here found that, if they had happened again, perhaps I would be granting a mistrial. But with these 2 comments and the instructions that were given,
I will declare a mistrial.
right, but we did not have a third comment. So
had the judge granted the mistrial after the second comment, would that have been an abuse of his discretion?
I don't believe it would have been an abuse of his discretion, but I don't believe it was an abuse of his discretion not to grant it here either. Because he is in the position, he has the discretion, he's in the position to best gauge the prejudicial effect of these comments. He was within his discretion. He did not abuse his discretion at that point to not grant the mistrial after those 2 comments. So
saying it twice wasn't prejudicial, but saying it 3 times would be prejudicial. That's your position?
On the trial court, the trial court was in the best position to figure that out. If he believed that third comment would have been overly prejudicial and worthy of a mistrial, then I believe that was within his discretion to do so. But it was also within his discretion here to gauge the prejudicial effect of just the 2 comments. And he did give those 2 curative instructions. He gave multiple instructions. He gave the impeachment instruction multiple times. It was throughout the trial. It was actually, during the actual impeachment. It was in the preliminary instructions before the closing. Then it was during closing. And then it was in the written instructions that they got. So they've gotten that impeachment instruction 3 or 4 times at that point. And then I think on the second comment, the court told the jury to disregard the prosecutor's comment. So there was curative instructions along with, the trial court's admonition to the state at that point. So it is our position here that these comments were not so prejudicial as to vitiate the entire trial. Obviously, this was a very, very long first-degree murder closing. It is over 50 pages long. These comments, while improper, did only take up less than a page, perhaps, of commentary. And so it's our position that they were not so prejudicial as to vitiate the entirety of the trial, and that the court did not abuse its discretion here. And as for issue 2, I know that my co-counsel, or my opposing counsel, relied on her brief, so I will do so as well, unless the court has any further questions for me.
Thank you.
Thank you. And I ask that you affirm.
May it please the court.
Yes.
Obviously, Your Honor, we addressed preservation in the briefs, but it is a lengthy objection to that impeachment testimony on transcripts, pages 502 to 503. So it is preserved. whether it's 2 times, whether it's 3 times, it's clearly improper, it's clearly inflammatory. It clearly misled the jury that they could consider this testimony as substantive evidence of guilt. I don't know how the jury unhears that, no matter how many instructions they hear about disregard that. You can only consider it for this, consider it for that.
At some point, it definitely would become reversible, but I think you're maybe overstating the argument a little bit, right? If that was the law, then a curative instruction would never work. And we would always say, well, the jury can't unhear that, and even though the trial court gave a curative instruction, we have to reverse.
Not necessarily, Your Honor. Sure, if it was one time. But now we're at the point where the prosecutor gets there, she says it once, the judge says, hey, you can't do that. He turns around, gets up and does it again. Okay, that should have been the mistrial there. We cannot ignore the fact this young man is serving life imprisonment now because of this. And that was really the only evidence, aside of the fact that he didn't seem shocked and he grabbed some marijuana on the way out the door, that tied him to this robbery. That's really it. That's really all this jury had to tie him to this robbery. And
was there any conduct after that came in to evidence?
No, it was really thin after that. There was some, and even the state kind of admitted that in closing, that was really, there wasn't much after that to tie him to this. Like, he was with them, but there wasn't much after the fact.
Did he change his appearance?
No.
Okay.
No, like they were pretty open about, like they had some Facebook posts, I think it was Instagram posts or something afterwards, but it wasn't really anything after the fact to tie him to this.
He didn't change his hair?
I read that somewhere.
I think they all did. I think that. But going up to the
Wasn't he arrested like weeks later?
Afterwards.
Looking very different?
But going up to the robbery and murder,
Right.
he used his own identity. He set up the robbery.
Where did he go? Didn't he go immediately after the
He went to the
murder
hotel room, I believe,
with
all of them
with all
together to try to figure out what to do next. But leading up to the marijuana buy, he used his own name. He bought marijuana from Mr. Berry
They
before.
borrowed a car from somebody,
Yes. He used his own name, his own phone number. He had cash on hand
but they borrowed a car.
from a friend,
Right.
I believe, yeah. But leading up to it, he didn't make any attempts to disguise who he was. He bought marijuana from Mr. Berry before. He didn't make any attempts to conceal that. So, my time is running out. Unless there are other questions from the court, I would ask you to reverse and award Mr. Waters a new trial. Thank you.